Honorable Chief Justice of the Supreme Court of Guyana, Justices of the Supreme Court of Guyana, Justice Pollard, retired Justice of the Caribbean Court of Justice, Vice President, Public Security, I've only just seen you, Kemraj. Welcome. His Excellency, the Ambassador for the United States to Guyana, Mr. Perry Holloway, UN World Bank representatives, Jacinta Odor and Elsa Krishnan, Mr. Brian Horn, Dr. Professor Thomas, the Chief Parliamentary Counsel, President of the Guyana Bar Association, Ms. Sanford. Have I missed anyone? Special invitees, comrades, ladies and gentlemen. The State Assets Recovery Bill 2016 introduces the State Assets Recovery Act of 2016, which seeks to establish the State Assets Recovery Agency, known as SARA, pursuant to the provisions of the United Nations Convention Against Corruption, 2003. And it's to recover through civil proceedings state property unlawfully acquired by a public official or any other person. Clause 6.1g of the bill encompasses the remit for today's consultation, and I quote, to raise public awareness on the dangers of corruption and enlist public support in combating corruption and other crimes, especially in relation to public officers and state property, end of quote. The advent of the new government saw President David Granger declaring that the fight against corruption was of the highest priority for the APNU-AFC coalition. His Excellency, in addressing the top brass of the public service at the Artachang Convention Center, stated his desire for, and I quote, a professional and non-bribable public service, end of quote. Moreover, the APNU-AFC government caused forensic audits to be carried out in many government departments and agencies, which fingered many public officials with unlawful conduct relating to state assets. In these circumstances, a groundswell of public opinion demanded the recovery of state assets from such corrupt public officials and their surrogates, and SARA was conceived with the collaboration of the UN World Bank and a British expert who worked together with the officers of the Attorney General's Chambers of the Government of Guyana. This act will apply to public officials, past and present. And so with these few words, I'd like to welcome you here and to declare open this consultation. Thank you very much.
I now call on Ambassador Perry Holloway to give his remarks.
Thank you very much. Thank you. Greetings to all. I promise my remarks will be short because here today, I think this event is about consultations and between you and these guys and others. I do want to commend the Attorney General and his whole team for taking on this effort and advancing it forward. And I think he did a great job of recognizing all the luminaries in the room. So to all of you, I also say on behalf of the U.S. government, President Obama and myself, warm greetings also to the members of the public who are here, lawyers who are here, and members of the press. I also give you a very warm greeting. I think no matter what your political party, your religious beliefs, your ethnic background, we can all agree that a strong rule of law is necessary for a country to be successful, prosperous, and safe. And rule of law begins with, quite frankly, laws. So I think that's why we're here today. This is a part of a democracy is the consultative process and talking about laws that are being considered. And so today I encourage all of you to speak up if you have doubts, if you have suggestions. That's what the process is about. I will not comment on the specifics of the law. I'm neither a Guyanese legal expert nor an international legal expert, but we have many in the room, I think, most Guyanese and from the international community. So I encourage everyone to take advantage of that expertise. I will say that my government fully supports the concept of a state assets recovery law. Such a bill will better enable Guyana to deal with corruption, whether it is by past, current, or future perpetrators of corrupt acts against the state and its assets. This law will bring Guyana, once it is consulted and agreed upon, into the 21st century. It will allow it, bring it into alignment, I think, as the Attorney General mentioned, with UN conventions and other international conventions to which Guyana is a party. So I think I began my short remarks by saying that rule of law begins with laws, and I will end by saying rule of law ends with people. So those that make the law, those that follow the law, and then those that have to enforce the law, and I think we have all three stakeholders in the room today. If you can have the best law in the world, but if it's not implemented properly, enforced, and followed, it will not prosper. So I encourage each and every one of you to do your part to get the word out, consult with your friends, colleagues, and everyone else. And again, I applaud the efforts of the government, the Attorney General's office, and others who have worked really hard on this bill, and I encourage everyone to participate vigorously. So with that, I will end my brief remarks and wish you all a great day.
Let me begin by acknowledging the facilitator who is running these proceedings today, to recognize the Minister of Legal Affairs and Attorney General who is spearheading this bill and the consultation that we're having, Mr. Perry Holiday, the United States Ambassador who just spoke, other distinguished persons within the Assembly and at the head table. I have a few brief remarks to make, and these remarks are directed essentially at expressing my gratitude to all those who have helped to make this draft bill a possibility and therefore set the stage for the implementation, I hope, by the Parliament of the State Assets Recovery Agency. And that is what I'll use my very limited time to do. First of all, I'd like to thank the then government of Guyana, which back in 2005 had supported the United Nations Convention Against Corruption, and in fact acceded to the convention in April of 2008. So this is something that started as far back as then. The previous government, a previous government of Guyana, not the present, had in fact signed on to the convention. Secondly, I'd like to thank the Inter-American Development Bank, because it was they who have helped to support the presence of a British legal expert with us for the entire duration until this point in time of our efforts to bring the bill to fruition. Thirdly, I'd like to thank this Stolen Assets Recovery Initiative, which is a subsidiary arm of the convention itself, which is financed, I think, by the United Nations and the World Bank. And they've contributed in considerable measure to the evolution of the bill that we have today. They've also participated in the first national consultation which we had back in January of this year, where for 3 days, 3 successive days, we met separately with a large number of stakeholders, including civil society, the judges, including the Chancellor of the Judiciary, other judges, the DPP, who I see is here today, and other legal personnel. We also met with the banking community, the private sector, leading professional associations during that 3-day consultation. The aim was during those 3 days to come to the decision on the type of bill which we feel is right for the circumstances of Guyana. And that bill is a civil, non-conviction based assets recovery bill, which is what we have before you today. So this consultation day is therefore the second round of consultations which we've had in the bill. I'd like also to express my gratitude to the international community, which has always been very helpful with us in this particular process, particularly the governments of Canada in alphabetical order, the European Union, Russia, United Kingdom, and United States of America. They've been helpful in a very timely manner whenever we sought assistance from them. They've provided technical and professional advice when requested. They've provided training whenever and wherever we are asked for it and wherever it is possible. And they continue to do so and have committed themselves to do so going forward into the future. They have also afforded us with lots of informational material to help to guide us in arriving at the type of bill which we need to, which we brought forward here today. We were also able to benefit from a number of international experts coming out of that engagement that they helped us with. In particular, we were able to get in touch with the International Chamber of Commerce, and through them Fraudnet, and through them the world's largest network of civil assets recovery specialists who have now moved into the field of public assets as well as civil assets. We were fortunate also during the process to be benefited as being participants in a colloquium which was held, to which we were specially invited, SARU, by the former Assistant Attorney General of the United States, who is Dean of the College of Law at the Florida International University. That colloquium focused on the fight against corruption and impunity in 2016 and beyond. At that colloquium, we were fortunate to meet the world-famous Attorney General of Guatemala, which everyone knows, and who has been instrumental in their struggle against corruption in Guatemala, and other participants. And we're part of that networking arrangement, and we have been significant beneficiaries of that, and we expect that that will go forward with time. Six, I would like to acknowledge also that when we established SARU, the government established SARU in July of 2015, that we're doing so as part of an intellectual tradition. The intellectual origins of the bill go back, I think, to at least 2014, when through various public discourses and discussions, media articles and so forth, there was a general evolution of the idea that we should have civil assets. We should have stolen assets recovery unit brought into place as part of a broader anti-corruption set of strategies. This discourse that we're having here today, I see as a further step along that chain of possibilities. I'd like also to recognize in the intellectual lineage, given this intellectual lineage, that we must publicly acknowledge with great deep gratitude the many contributions made by the Guyanese diaspora. Many persons from abroad living in Guyanese from abroad in various countries, almost every country in the world I can think of, significant country where there are job opportunities and so on, have written to us and have given us encouragement in what we're doing. And all of them, I think, are coming from different cultural standpoints, but they have in common the idea that we should not allow anyone to assert that the Guyanese Constitution provides citizens who are claiming property that is stolen for the state as their constitutional right. They're very firm in recognizing that. Next, I would like to acknowledge that many citizens and many individuals, many professional organizations have been very helpful to us, and they've sought no recognition of this in public, so I wouldn't name them, but they've been extremely helpful to us in providing advice, guidance, counsel, information, and helping us to build the unit that we have, and more particularly to build the structure and form of the legislation that we're here to discuss today. Last and by no means least, I'd like to express my deepest gratitude and appreciation to the Ministry of Legal Affairs and the Attorney General and their hard-working team of officials who, often in very close collaboration with the personnel from SARU, have helped to bring this bill to the position where it is today to be discussed. Throughout this entire process, we benefited from the guidance provided by the Attorney General. And the fact that we are a civil-based assets recovery unit fits into the fact that he, as Attorney General, is in charge of the civil affairs of the state. Thank you very much.
The purpose of the bill and of its importance to Guyana. So I'm sure we all would like to know the content of the bill. Comment to give the overview of the proposed legislation is the Chief Parliamentary Counsel, Mr. Durjon.
With all protocols having been observed, I would proceed to make my few remarks. I would begin by reading the long title, which has a number of, which mentions a number of the salient features in the bill. It reads, "An act to establish a state asset recovery agency in consonance with the United Nations Convention Against Corruption, 2003, headed by a director who shall be a corporation's sole, to recover through civil proceedings state property unlawfully acquired by a public official or any other person, to provide for the investigations leading to the granting by the High Court of restraint and civil recovery orders in respect of unlawfully acquired property, also to engage in international cooperation in recovery of stolen assets of states within the contemplation of the Act, and for related matters." Now, Part 1 of the bill merely states the definitions. Part 2 of the bill establishes the State Asset Recovery Agency with a director who shall be a corporation's sole. The director and the deputy director shall be appointed by the National Assembly on a recommendation of the Appointments Committee of the National Assembly. Now, the functions of SARA include the investigation into whether state property was obtained through unlawful conduct involving a public official or any other person, and the tracing and identifying of property wherever situated, suspected to be state property obtained from unlawful conduct involving a public official or any other person. SARA may take appropriate action to deprive any person of property which in effect is stolen property by instituting proceedings in the court to recover the state property or for freezing the proceeds of corruption. SARA shall raise awareness, as the Honourable Attorney General has pointed out. SARA shall raise awareness of the dangers of corruption and enlist support in combating corruption and other crimes. The functions of SARA shall be discharged by the director, who shall consider whether recovery of state property may be better secured by means of criminal investigation. The director may seek the assistance of the Commissioner of Police in discharging in the discharge of his functions, and the Commissioner of Police shall ensure the provision of needed assistance. The Director should prepare an annual plan regarding the discharge of SARA's functions and include in the plan an estimate of revenues and expenditures during the financial year. The Director and staff of SARA shall be subject to the Code of Conduct prescribed in Schedule 2 of the Integrity Commission Act. Part 3 of the bill deals with the establishment of the Recovery of State Assets Fund for the purpose of receiving credits from civil recovery orders and other payments. 25% of that fund is credited to SARA, and 75% shall go into the consolidated fund, and the Director may make disbursements from this fund. Part 4 of the bill deals with civil recovery and the preservation of state property obtained through unlawful conduct. Conduct is unlawful if it constitutes an offense under the criminal law or any other law in Guyana. All proceedings under the Act shall be civil proceedings, and the standard of proof shall be on the balance of probabilities. The Director shall take steps for the purpose of civil recovery of state property derived directly or indirectly from unlawful conduct involving public officials or any other person. The Director may undertake civil recovery investigations into whether property is state property obtained from unlawful conduct involving a state official. There may be an investigation to determine whether property should be subject to a restraint order or civil recovery order, and to facilitate the investigation, the court may, upon application, issue a disclosure order, a customer information order, a production order, a search and seizure order, an account monitoring order. A person may make a disclosure to the Director in relation to SARA's functions. There is a list of 12 permitted persons who are bound to make disclosure to the Director of relevant information. Where on application to the court by an authorized officer, it appears to the court on evidence tendered by the applicant there are reasonable grounds to believe that property or specified property constitutes directly or indirectly state property obtained or derived from unlawful conduct involving a public official or any other person, the court may make a restraint order prohibiting the dealing with the property or diminishing its value. A restraint order shall not be made where the particular property does not derive from unlawful conduct. A restraint order may be made on an ex parte application to a judge in chambers and shall continue in force until the determination of the application for a civil recovery order. A person with an interest in property can apply to the court for a variation of restraint order or may apply for living expenses or legal expenses. The court may, when it makes a restraint order or at any later time, make any ancillary order that the court considers appropriate, including an order for varying the interest in property, an order for the examination on oath of the owner of an interest in the property, subject to the restraint order, an order authorizing the seizure of property. An application for an ancillary order may be made by an authorized officer of SARA, an asset manager, or any other person. The Director or other authorized officer may apply to the court for a civil recovery order against any person believed to be holding recoverable property. A court may make a civil recovery order in relation to property subject to a restraint order or any other property. But property will not be recoverable from a person who is a bona fide purchaser of the property without notice that it is acquired through unlawful conduct. An application for a civil recovery order shall be made by summons supported by affidavit. The director shall give notice of an application for civil recovery to the respondent. A civil recovery order shall operate to deprive the respondent of his rights in the property, and the property shall stand transferred to the state. Transferred to the court appointed asset manager. The property shall stand transferred to the court appointed asset manager. A person commits an offense where that person disposes or otherwise deals with an interest in property that is subject of a civil recovery order and may be dealt with for contempt of court. A civil recovery order may be made in respect of interest in property that were disclosed by a person against whom a civil recovery order was made on application by the director to the court for an order forfeiting and vesting the property, the vesting in the state the said property. Where the court decides in an application for a restraint order that property is not recoverable, the owner may be granted compensation. Where property is not recoverable, that is not tainted with corruption. Where the director determines not to proceed by civil recovery proceedings, now this is another avenue the director may go, where the director determines not to proceed by civil recovery proceedings, the director may serve on the Commissioner General of the Inland Revenue Authority a notice that vests, notwithstanding any other law, in the director the revenue functions of the Commissioner General relating to a person's income, profits, or charitable gains where it is suspected that they arise from the person's unlawful conduct. The Commissioner General is not divested of his functions, but shall cooperate with the director and facilitate the work of the director. No proceedings shall be brought for civil recovery order in respect of recovered property after the expiration of 12 years or where the value of the property is below $10 million. Now, Part 4 deals with what I've referred to before: disclosure order, custom information order, production order, search warrant, and so on. And I'm not going to deal with this. Now, Part 6 of the bill deals with international cooperation. It provides that the Minister of Legal Affairs, our Attorney General, may enter into property sharing agreements on the basis of reciprocity. The competent authority shall cooperate with its counterpart of a foreign state to provide assistance in matters concerning recovery of property. The court or competent authority, and the competent authority here in Guyana is the Honorable Attorney General, the court or competent authority may take appropriate action in respect of a foreign request to treat, identify, trace, produce, seize, restrain, or recover property or assets. A document issued by or on behalf of a government of a foreign state and stating the terms of a corresponding law in that state shall be admitted as evidence in proceedings under this Act. Where the director, in carrying out a civil recovery investigation, the director may employ the provisions of any agreement entered into between the director and any government department or a public authority of any foreign state or territory. The Attorney General or the director may initiate legal proceedings in the court of a foreign state, subject to the provisions of the national law of that state, and the director shall inform the Minister of Foreign Affairs of any action taken. Evidence obtained in pursuance of a letter of request shall not be used by the director for any purpose other than that for which it was obtained, except where there is a particular dispensation to that rule. Part 7, and the last part, deals with miscellaneous matters. This part grants immunity to the director, SARA staff, a person acting on behalf of SARA, an asset manager, or a person appointed by the court for any act done in good faith in performance of any duty under the Act. There are provisions for protection for SARA staff. It is a criminal offense to threaten a member of SARA staff. Existing members of the staff of SARA shall become members of the staff of, existing members of SARU, that is the present unincorporated organization, shall become members of the staff of SARA, which we are providing for in this bill, when the Act comes into force, and 6 months after, the Parliamentary Committee on Appointment shall recommend to the National Assembly a person to be appointed director and a person deputy director as SARA. The minister may make regulations for the due administration of the Act and may impose a penalty for breach of the regulations. I thank you.